One of the nice parts about doing my own email service and doing my own videos, I can talk about whatever I want without fear of somebody editing it. And that includes sometimes complaining about stuff that bothers me or disturbs me. So one of the cases that's in the Wisconsin cases this month's flu, there are two of them, two unpublished but citable contempt cases. And one of them is my case, and it's a case that I lost. And at trial, a court dismissed the contempt proceedings, and it just this month got affirmed on appeal. So I'm not going to sit here and whine about the poor decisions by the courts. Well, okay, I'll whine a little bit about the poor decisions by the courts, but my primary purpose is not just whining, but also is a couple of take-home and a few lessons in terms of the case. The case that I handled is the Krause case, which again is in this month's flu, and it's a contempt case where the husband in the divorce was under a requirement to provide tax returns to his ex-wife. He didn't do it, and shortly after the divorce, and there was a proceeding a couple years later where the trial court, among other things, specifically ordered him, hey, you're supposed to provide both your personal and your business tax returns to your ex-wife, and made an additional order. So it's not just one of those orders to provide tax returns that's buried in page 8 of the marital settlement agreement. In addition, there's a subsequent explicit order for him to provide tax returns. Well, what Mrs. Krause did when she didn't get the tax returns was not to bring an action in court to find him in contempt, but to wait until the child was 18 and out of high school. Her theory being, at least, is that if she started a contempt action, it would very likely engender a counteraction for custody. And we hear this a lot from clients that I don't want to start the war, start the battle. So she didn't contact me until child support had terminated, and said, can she still bring the action for contempt, because she hadn't gotten tax returns in a number of years. And I had read the Frisch versus Heinrich case a number of times. I reread it a few more times. And Frisch versus Heinrich says that failure to provide tax returns constitutes a, quote, continuing contempt, end quote. Doesn't explicitly say continuing till when, but one would think that it would be continuing until the ability to seek redress, which is 20 years after child support terminates, is the statute of limitations. And if it's a continuing contempt, there's a continuing injury in terms of the failure to get the tax returns and seek an increase in child support. I realized I had a problem in terms of the remedy, in terms of what would have happened if she had gotten the tax returns and proving that she would have received an increase in child support. But I felt, okay, we'll address that when we get to it. The easy part is there's a clear court order, number one, in contempt. Number two, he clearly didn't comply with it. There's no dispute about that. And third, there's no reason or excuse for him not to comply with it. And those are the three factors in terms of remedial contempt. A court order, a failure to comply with a court order, and no inability to be unable to comply with the court order. So I'm thinking this is all slam dunk, and I'll deal with the second issue in terms of what the remedy should be later. And I go to court and argue it, and the judge says, oh, no. She shouldn't have waited till the child was 18. He is not in arrears in the child support. He's paid everything he was ordered to pay. He also claims he made some additional payments on behalf of the child. So this wasn't an intent not to violate the court order, and I'm dismissing the contempt. And it's one of those things in court where you're just shocked. You just thought, well, this is a slam dunk, and I'm ready to go on and say, now, Judge, about the remedy. And she says, Mr. Herman, we don't get there. I've dismissed the contempt. I mean, that didn't happen, but that's what it felt like. I'm ready to go to part two and argue that, because the first part is such a slam dunk. So I walk out of court totally shell-shocked at this, and taken an appeal to the Court of Appeals, thinking Frisch versus Heinrich says continuing contempt. the Supreme Court, to the best of my knowledge, is a superior court to the Court of Appeals. If this trial judge, doesn't want to follow the Supreme Court, and Frisch is a Supreme Court case, Court of Appeals should know there's a inferior court to the Supreme Court, and they should want to follow it. And continuing contempt means continuing, okay? Not just continuing for a few more months till the child's 18, but continuing as long as a remedy is available. So I took an appeal, and you can read the decision. The Court of Appeals, in their idiocy, I didn't say that, by the way. I totally deny using that word. In their cowardice, that's a better term, find that this is a reasonable exercise of discretion. Really. Just ignoring what the law was in Frisch about continuing contempt and finding that the trial court reasonably exercised its discretion dismissing the contempt. So that's it. My client hasn't authorized a review to the Supreme Court. I think she's probably tired of all the fighting and arguing, and that's where the case is going to lie. Remember, it is not a precedential case because it's not published, but it is a case that can be cited for its persuasive value. So there are a few takeaways from this. Number one is, if you represent the payee, the person receiving the money, usually but not always the ex-wife, you better tell her that if she's not getting tax returns, that she better bring that contempt action before child support terminates, or she very well may be SOL. Second, if you represent the payor, again, usually the ex-husband, and you're coming up on the termination of child support, I think it's perfectly fine under this case to tell him, you know what, if you've had a substantial increase in income, don't provide the tax returns because you will not be in violation of the court order and you won't be found in contempt because she doesn't have any remedies. You know, as lawyers, it's not a matter of whether we like the law or don't like the law. We have obligations to our clients to tell them what's in their best interest, as long as it's not illegal or unethical in any sense, and this isn't. The Court of Appeals thinks the law is that after child support terminates, that there's no remedy, and that continuing contempt and Frisch doesn't mean what I thought it meant. A lot of other people I talk to think it means we are governed by what the courts say, not by what our personal feelings are. So I'm very surprised and honestly upset and a little disappointed in terms of the way the courts handled this, and because it's something that's to me, continuing contempt is plain language and has a plain and obvious meaning. But read the case and form your own opinion. There's one other takeaway from this. I traditionally tell clients that when we walk across the threshold into the courthouse, they receive from me one and only one guarantee. And that guarantee is that I'll do the best job for them that I'm professionally capable of doing. Beyond that, anything can happen in court. And this case serves as the best example of that in recent memory, at least for me, in terms of a case in which I was convinced that in terms of the strict reading of the law, in terms of the equities, in terms of his having no excuse for not providing tax returns, including the fact that he was expressly ordered to do so after the divorce and didn't do that, that this should have been, as I said, a slam dunk. Fortunately, I did have that conversation with my client, and as I do with all clients, because there are no guarantees going into court, and anything could happen. So the third takeaway from this is, as I'm fond of preaching, one of the reasons why lawyers recommend compromises to clients to result in settlements. Even if we think we're right, even if we think the law is on our side, even if we think the equity is on our side, even if we're thinking there is no way under God's green earth, taking all that into account, that we could possibly lose. Guess what? We can. And every case, no matter how strong it seems, should be the basis of seeking a resolution and a settlement, which requires certain compromises to get there.